Hello and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. A billion-ringgit lawsuit by a corporation against multiple media organizations and individuals has drawn sharp criticism or condemnation from human rights organizations who warn it bears the hallmarks of a strategic lawsuit against public participation, better known as SLAPP. Now, critics say such lawsuits are not about seeking legal remedy, but about silencing public scrutiny. So tonight on the show, we want to explore where is that line between protecting reputation and suppressing public interest reporting, and does Malaysia's legal framework do enough to prevent the courts from being used as a tool of intimidation? Joining me on the line now is human rights lawyer Edmund Bon. He is the representative of Malaysia to the ASEAN Intergovernmental Organization on Human Rights, of which Malaysia was the chair for 2025. Edmund, thank you so much for joining me on the show. You have long been an advocate of strengthening protections against the use of SLAPP. Now, maybe you can begin our conversation by explaining how SLAPP cases are typically orchestrated in Malaysia. How should we understand the types of legal tools that are most commonly used here?
So SLAPP cases is relatively new as a term, but generally it's been cases relating to defamation. So where, for example, residents complain about pollution, the orang asli complain about the rivers being polluted by factories. We have freedom of speech issues, corruption issues, where there are complaints made, researchers, academics, NGOs raising those complaints in the public domain against certain individuals or organizations. The organizations will then go to court, one, through a civil means to seek an injunction or file a court case for defamation. So that's a form of a SLAPP suit, in a sense that they want to say that whatever has been raised is untrue and false, and more interestingly is to seek an injunction, an early injunction. So an early injunction means they will go to court and say to the court, this is very important, please stop all publication in the meantime the court case goes on. And as we know, court cases may go on for 2 years, 3 years, and if the injunction is given, then no one can speak about the issue. No one can speak about corruption, no one can speak about the polluted river, no one can speak about what has happened to the orang asli. So that's a form of SLAPP, S-L-A-P-P. It's a form of trying to silence dissent, trying to silence people raising their voices.
Right.
Because SLAPP also has the criminal side. So we have seen the criminal machinery being used, police reports being lodged, raids being done, and investigations started over certain allegations. So SLAPP comes in these two forms.
Okay. Edmund, you mentioned defamation a bit earlier. Talk to me about the difference between genuine protection against defamation versus the elements of SLAPP. How do we determine whether there are elements of SLAPP within a litigation or within a case?
So freedom of expression in human rights is not unrestricted. We have to accept that there are some restrictions, and the restrictions are very narrow. So if you incite race, religious hatred, seek people, calling for people to die, those things, they are not free speech. They are not protected speech. But the federal court has said recently that genuine political discourse, genuine political critique of the government, of issues that are of interest to the public, corruption, for example, these are protected speech. Therefore, government authorities, businesses who are affected by this speech should actually use their voices to rebut those speeches. But trying to use the courts, use the judicial machinery to silence voices would be quite unwarranted. Of course, there are some type of defamatory statements that are completely false, completely misleading, and they are entitled to protect their reputation. But in terms of balancing those interests, a lot of times our courts have said we need to protect free speech. Now, your question is very interesting because SLAPP is recent, and there are some developments around the world, in California, in Thailand, in the Philippines, in Indonesia, for example, where there's some new legislation to try and have a better balance and a fine line. We don't have that in Malaysia at the moment. So I cannot answer the question because it goes by case basis. There are some statements that obviously are defamatory, but there are some statements that if there is evidence, there is of corruption, then the issue needs to be investigated. The issue should not be to take it to court and then stop the whistleblowers or stop those that are raising their voices. Because we know in a democracy, we need to have protected speech that is free and fair.
Right. In the case of Malaysia, who tends to initiate these lawsuits? I'm curious to know, is this government sanctioned? Is it where are SLAPP cases coming from typically?
Typically from businesses, one, where residents complain about a polluted river, for example, and when it goes viral, now there's a lot of social media channels, the company and business will then say, okay, I think this is going too far, let's go to court. But second of all, government machinery. We have seen politicians, we have seen state agencies, we have seen both federal and state governments, we have seen local governments, we have seen commissions filing court suits. So a SLAPP suit can be generally anyone, started by anyone, but generally around the world, not only in Malaysia, the plaintiff is always somebody in a greater position of power. And that's where we need to remember. In a democracy, the democracy is trying to balance that power, and free speech allows the weaker segments of society, those like the residents, the orang asli, those who only have voices, the general public, the only have voices, we are the weaker segments of society. Government machinery, businesses, big corporations have a lot of resources. They are wealthy. So they go to court, and when they go to court, it's David and Goliath because they are strong, they have lawyers, they have a lot of money, they can go for litigation for years on end. The weaker power is the one that only has free speech to raise issues of human rights concerns.
Right. Yeah, and I think also in the Malaysian case with so many state-owned enterprises, GLCs, GLICs, I think that also adds another dimension of this power imbalance that you referred to, Edmund. I also wanted to ask you about how SLAPP relates to business and human rights, because as the Malaysian rep to Aicha, you also had the National Baseline Assessment on Business and Human Rights. I'm curious to know, how do we think about business-related SLAPPs and how that's recognized as a human rights issue, as a need to protect it for democratic safeguards?
Yeah, so it's not a new phenomenon only in Malaysia. I want to say that the Malaysian government has taken very bold steps in the National Baseline Assessment, and then now in the National Action Plan for Business and Human Rights to 2030, to actually develop an anti-SLAPP law or anti-SLAPP legislation. That's one of the targets in the National Action Plan, and civil society is assisting the government to that. I think it's important to try and strengthen the court procedures, try and strengthen elements of what the court can look at when there's a striking out application. So for example, if there's a defamation case, what happens somewhere else outside our jurisdiction, the defendant, the resident or the orang asli can actually, orang asal can actually file a striking out application and say, oh no, this defamation case is not genuinely to protect reputation, but actually is to silence us. It's actually to get an injunction to silence us, and the court can look into some elements of it. At the moment, the courts look into a little bit of it through the lens of defamation, but through the lens of SLAPP, we have not yet developed that kind of weaponry, and I think we need to amend our rules and our law for that. But it takes time because the debate is still not clear-cut. What type of elements do we need to look at?
Right. Well, based on your work and your observations from other countries, what do other countries do that make it possible for an anti-SLAPP law? What does that type of legislation look like? And the other thing I'm curious about is how does the court system respond to that? Are judges equipped to identify and dismiss SLAPP cases early, these early injunctions, or does the law need to change first?
So I speak to about other jurisdictions. The other jurisdictions, yes, the courts are empowered to strike it out. And what they actually look at is how genuine the defamation claim is. They will look at the claim on the face of it. For example, if it's an investigative journalistic article, there are resources named or there are no sources named, but there is some sort of a justification for it. And instead of investigating the claim, the SLAPP claim is brought. So the judge might say, I'm just paraphrasing, might say, oh, this doesn't look like a genuine claim. The article looks, yeah, there are some sensationalism, but there is some evidence there. So yeah, I think your claim would look like a SLAPP claim and I would strike it out. But if it's a 50-50 thing, then sometimes the injunction, the pre-trial injunction that will take 2 or 3 years is not given, but the court case then proceeds. The important thing is the pre-trial injunction. The pre-trial injunction is normally used by by businesses in the Malaysian courts before the trial, as I mentioned. If the trial goes on for 2 years and the injunction is provided or given, nobody can speak about the case for 2 years. And that's really, really serious because that's the target of slappers. Slappers want to get the injunction so that nobody speaks about the case, nobody brings up the case for the next 2 years, 3 years. By that time, everybody would have forgotten about the case when the case actually comes up to trial. And that's why you see in Malaysia a lot or many cases, and to the credit of the courts as well and mediators, a lot of cases by the time they come up, the statement is really stale, and the plaintiffs and defendant would normally mediate and settle the matter because, unless you are really in it for the money, there's no point going on.
Right. So you said anti-SLAPP laws take a long time, or may take a long time to materialize in Malaysia. How can we protect public participation in the meantime? Are there tools at our disposal?
Yes, the Malaysian courts have already said. I mentioned the Hedi Kuas case, where our firm represented her. It's very clear that the federal court have said, Section 233, you cannot use Section 233 simply as it used to be. 233 can only be used in a very limited circumstance, issues of what is now known as the 3R, but for genuine political discourse, genuine political critique, you cannot use it. So that means that we need to continue supporting our flourishing civil society. Malaysia is very lucky because we have civil society from all backgrounds, right down to the grassroots, up to Suhakam. I think that civil society participation needs to be supported. Again, we have seen a lot of independent media as well, where there are issues that are coming up. We need to support those who are raising these issues.
Right. Edmund, before I wrap up, I just want to circle back. Forgive me for circling back to the beginning of our conversation where you said there are two types of defamation and then there's a criminal side with police reports. Can you elaborate very quickly about that? I'm curious to know how SLAPP is used or what elements of SLAPP in using police reports.
Section 233 is used, criminal defamation is used, sedition is used. These are forms of, these are laws that are still in Malaysia that are used by slappers, including government, those who are in state, to stop people from speaking up. So those are criminal elements, not so much using the courts as yet, but using our law enforcement. So using, for example, the police, the MACC, whichever commission or agencies that are involved to investigate and harass those that are raising the issues. I'm not saying, and I want to be very clear, I'm not here to talk about any particular case. I'm not here to be on anyone's side. If you're asking me about how SLAPP works and how it's seen around the world and how it's seen in Malaysia, these are the basic elements.
Definitely. Edmund, thank you so much for being on the show with me today. Human rights lawyer Edmund Bon, he's the Malaysian representative to AICHA. We're going to take a quick break, but we'll be back with more on SLAPP. Stay tuned to consider this. Hi, welcome back to Consider This. I'm Melisa Idris. The Centre for Independent Journalism recently raised alarm over a billion-ringgit corporate lawsuit targeting several media outlets and individuals, describing it as a case with elements of SLAPP, or strategic lawsuit against public participation. Now, at stake here is more than just one case. It raises broader questions about what happens when the threat of legal action becomes a deterrent to speaking out. Joining me on the show now is the Executive Director of CIJ, Wathshlah Naidu. Wathshlah, thank you so much for being on the show with me today. Beyond the statement that you recently put out, I recall that CIJ had published a report about SLAPP, the use of SLAPP in Malaysia, and this was about 4 years ago. I'm curious to know how times have changed, or whether times have changed. How would you describe the prevalence of SLAPP use in Malaysia currently? Has the situation changed at all?
Yeah. Hi, Malaysia. Hi, Melisa. And hi, Malaysia, too. It's good to be back on Astro. I just want to, the report basically was one of the first attempts by CIJ to document some of the cases, right? And we looked at SLAPP tactics used by not just corporations, but also high-ranking public officials here in Malaysia. And we saw that as a means of intimidating critics, media, journalists specifically, activists and opposition figures, right? And a lot of those cases when we documented were on environmental issues, corruption, or even alleged corporate wrongdoing. But what we are seeing now is that this is really not a historical problem. It is something that is growing. And the tactic, as we say, is continuing to be used against media and human rights defenders. Right? And what we are seeing is two levels. One is general use of defamation laws, right? Both civil defamation as well as criminal defamation under our penal code, right? And the second level that we are seeing, and this is actually creating an added layer of chilling effect, it's the use of the whole arsenal of legal tools that we have to push for legal harassment or persecution, that leads to arrest, detention, investigation. And in fact, it does not even always amount to prosecution. And the case that you were referring to, that we issued a statement on, was a huge business company, a corporation, filing a disproportionate claim for damages, 1 billion ringgit, against multiple defenders, multiple media organizations, individuals, for reporting on alleged migrant workers exploitation. And this is not unique. The last couple of years, we saw a number of instances, in fact, even this year related to the same case somewhat. We also saw the chief, the head of the Malaysian Anti-Corruption Commission, filing again another substantial defamation lawsuit against two defendants, right? Both Bloomberg in New York and Bloomberg in Malaysia, 100 million ringgit, over news article alleging issues with his own share holding. We saw I think in 2025, the cross-border case of Australian commentator Murray Hunter, where MCMC pursued both criminal and civil defamation. And these are just a few, and I can give you a whole list of other cases, and happy to do so.
Right.
Yeah, but I also want to raise then the other aspect, right, that goes beyond defamation or the use of defamation laws, which are, instances where we had an activist in Sabah, Mukmin Naktang, who was arrested and investigated for sedition on the basis of his advocacy, right, and comments on rights of indigenous community. We've always have, Suaram coming under attack, and just last year, former executive director Sivan Duresami and Azura were also being investigated for the memorandum that they wanted to submit to KDN. Right. And these are a number of cases which shows that this is ongoing, it persists, and it is really creating a threat against public participation in Malaysia.
Right. Wathshlah, you mentioned a bit earlier, sometimes even when these cases don't succeed, there's still an impact to the target of SLAPP cases. Talk to me a little bit about that, the psychological, the financial, the professional toll that these SLAPP lawsuits take on those targeted, especially when you juxtapose against, I think there's some bigger newsrooms, you mentioned the multinational, international newsrooms versus smaller independent newsrooms, NGOs, individuals who may not have the financial wherewithal to withstand SLAPP cases.
And I think this is critical because SLAPP in itself, the reason why this was coined is because it's something that is used against public participation. That means it's targeting particularly people like media, corporations, individual journalists, and activists or human rights defenders who are critical, who bring out wrongdoings, who are also whistleblowers, right? And the intention of this of SLAPP is not necessarily directly to deal with their own reputation. Yes, it is an element of it, but it's really intended to stop from further criticism, further reporting of this. That means it's using the law then to create this protracted legal process with huge, highly, huge financial burden, right? But the impact has multi-level because, of course, it's easier to see the financial toll, right? Extremely costly legal defense, and not many people can actually afford this. We don't have huge funds to support these kinds of cases. In fact, even legal aid is limited. And that would mean that your own personal savings are being drained. And none of us, including, I would say, CIJ, can afford protracted litigation, right? And very often, this might even lead many of these individuals and organizations to settle. Or the other element would be to self-censor. And then if we look, because it's so protracted, because it's so draining, there is a huge psychological drain as well, because the impact would be you face stress, you face uncertainty, and there's also own reputational damage because we don't even know if the cases are ultimately going to be acquitted or that the case is going to be dismissed. The process in itself can be rather debilitating, right, psychologically, because it can be seen as a punishment. And that's huge, of course, the professional repercussions where, small media entities, you said it, right, media entities may have their own pool of lawyers to help them, but small media entities, small civil society organizations don't have this, right? And then we are then obviously, more at risk of facing career damages or reputation, right? But I think that the larger impact would be the chilling effect on public participation, because this is where, as it is, if we are already facing other forms of censorship and self-censorship, but if this continues as a tactic and a trend, people are going to self-censor. Media is going to be really fearful. Small media entities, especially small media houses, as I said, they might not even have in-house lawyers, right? What more other support? They would be really careful about how they, one, carry out their investigative journalism, but second thing is also how they report on these allegations, right? And these allegations are definitely, if you look at most of these cases, they are cases of public interest. Right. That's why SLAPP, we use the term SLAPP. It's not for your one-on-one individuals, politicians fighting amongst themselves with defamation claims. These are big corporations against either big entities or individuals and smaller entities.
Right. So what we learned from my conversation earlier with Edmund Bon was that anti-SLAPP legislation is being introduced around the world, but may take some time for that legal reform to hit our shores in Malaysia. I'm curious to know, Wathshlah, how you see this. Beyond the legal reform aspect, is there anything that can be done in the meantime to protect or even resist SLAPP litigation?
Yeah, I think I'm always very, very concerned whenever we introduce new laws in Malaysia. The last 2 years, especially, our track record hasn't been the best, right? So what I would say, yes, while we are considering, having a robust legal framework like in Thailand or Philippines, which has, moved towards how they're looking at judicial and legal approaches to SLAPP, I think the alternative would be to look at other policy measures. For example, as I said earlier, a lot of these SLAPP cases are cases of public interest, right? So if it's not media, it's also attack against civil society or other whistleblowers. So our whistleblower protection, again, should be really strengthened, so that individuals who are exposing these wrongdoings are then shielded or protected against retaliation, and this retaliation could, as I said, include litigation. The other thing, especially when it comes to media, I think generally Malaysian public, Malaysian corporation, businesses, as well as the government, including enforcement and the legal regime, should take cognizance that we have a Malaysian Media Council. So a lot of these cases, I'm looking at the number of cases just in 2026, right? Most of these cases should have been referred to the Media Council, right? They have set up their grievance mechanisms, their complaints mechanism. It provides space for non-adversarial, non-confrontation, non-punitive measures, right? So if it's really about reporting ethically, fair reporting, you don't need to invoke your defamation laws, right? So the third thing I would say under this would be reform and repeal of a lot of our laws that criminalizes speech, right? So one of the issue here is not just, as I said, about civil defamation, it's about our criminal framework, which allows for misuse of these laws as tools, right? So, Penal Code Provision 499 and Fine 500 has been invoked by high-ranking officials on criminal defamation. Sedition Act, Communications Multimedia Act, these are forms of also legal harassment. One other thing I want to raise is I think we need better support mechanism. I mentioned earlier about legal aid, but also in terms of pro bono support of network of lawyers who can provide these practical defenses. For small, as I said, for small media organization, for activists, civil society, human rights defenders, this is going to be critical.
Right.
And one last thing perhaps that we need to do is really foster a culture of open debate, right? Respect dissent, look at criticism as a legitimate part of participation and accountability.
Right. I hear you. Thank you so much, Wathshlah Naidu from the Centre for Independent Journalism, wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching, and good night.